our speaker, after I briefly introduce him, we have Tyler Walchanowicz here with us today. He's been a part of the Friedman, Nemechek, Long, and Grant team since 2020, where he has passionately represented hundreds of individuals, serving as a dedicated advocate for those in need. Tyler brings a unique and diverse background into his practice, allowing him to approach each case with individualized strategies. Whether defending clients accused of wrongdoing or championing justice for those harmed by others, Tyler is unwavering in his commitment to uncovering the truth and ensuring every client receives a fair and just outcome. As a key member of the firm's Title IX and school disciplinary practice, Tyler regularly serves as an advisor to students and staff facing allegations or experiencing misconduct, including sexual assaults, hazing, and other policy violations. His expertise extends nationwide, where he has guided and advised clients across the country. In addition to his advisory role, Tyler is recognized as a thought leader in this field. Tyler, thank you for giving us your time this afternoon. Looking forward to your presentation. Take it away.
All right, thank you, Dominica, and thanks everybody for having me and tuning in. As Dominica said, I've been with the firm since 2020. And together with Eric Long make up, I guess, 50% of our firm's Title IX and student discipline matter. So excited to be here and excited to give this talk. So you can go on to the next slide, Dominica, and thanks for manning that. So first want to just briefly talk about what is Title IX. I'm sure most of you have heard about it by now. It's really been more in the airwaves and in the news recently over the last decade than ever before. But it is a federal rights civil law. Civil law in the United States of America was passed as part of the Education Amendments of 1972. And what it does is it's an anti-discrimination law. And so it protects individuals on the basis of sex in education programs or activities that receive federal financial assistance. And so basically, any school you can think of, whether public or private, more times than not, receives some form of federal assistance. There are a few private schools that are across the country that are not subjected to Title IX, but otherwise almost every school in America has to deal with Title IX and has to comply with it. The direct quote from Title IX is, "No person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination in any education program or activity receiving federal financial assistance." It is a law, and you can go to the next slide, Dominica. It is a law that is kind of ever evolving. When Title IX first started, it was really about leveling the playing fields for the opportunities men and women have in education. And particularly when a lot of people think about it, they think about athletics. You may have heard of schools or colleges cutting sports programs or adding sports programs, making sure that there are an equal amount of men's teams and women's teams, that funding is even, and that the opportunities for male athletes and female athletes are consistent. And that's kind of what Title IX started out as. It has slowly evolved, and we'll get into that evolution a little bit more here in a minute, but most of the court cases and most of the fighting going on in the area of Title IX does not deal with sports anymore. You have your occasional lawsuits that you hear about in athletics, but for the most part, schools now understand that those opportunities that they provide to men and women, as far as extracurriculars, whether it's sports or else, they need to be equal. Most schools get that. Instead, in today's world, most of the issues we are seeing from Title IX really stem from a school's handling of their disciplinary process, and particularly complaints of gender-based misconduct. And you'll see as we get into this, Title IX is one of those laws that everybody is upset with it at some point, and everybody likes it at some point because of the shifts it's taken. Dominica, if you don't mind. So to understand why we see this shift, it's important to note that Title IX is governed and regulated by the U.S. Department of Education. And what that means is that whenever a new president gets elected and the U.S. Department of Education changes, so does Title IX. And so we saw in 2020 when Trump came in, and Dominica, if you want to go to the next slide, we saw in 2020 was the most recent change to go into actual effect, and we'll talk about that in a minute as well. But just a quick background. So it wasn't until 2011 that schools really started receiving pressure from the government to curb sexual misconduct. There was a 2011 Dear Colleague letter that basically told schools they need to have a system in place to address sexual harassment and sexual misconduct. And they ruled that sexual harassment and sexual misconduct is a form of discrimination. And so when schools received this letter, what we saw is they really took it one step further and said, well, to address it, we're just going to punish all of the allegations that come forward. And what we saw was really an unfair process that schools were employing, where there would be an allegation, there wouldn't be a whole lot of room for argument or for both sides to present their case. Schools were just reacting with a very heavy fist. And so in 2017, these concerns came back to the government's attention, and they actually withdrew that 2011 guidance in an effort to rectify kind of this perceived lack of fairness and lack of due process. When Trump got elected in 2020, that's when we first saw the first actual regulations that went into place. And we'll talk a little bit about what those regulations meant. But for the first time, it wasn't just a guidance from the U.S. Department of Education. It was an actual law that set forth what schools needed to do to handle these allegations when they received them, when discussing punishment or lack of punishment against the students who were accused of this misconduct, and so forth. And so those those regulations went into effect August 14th of 2020, and for more or less have remained in effect since then. In 2022, the U.S. Department of Education released proposed changes to Title IX and opened it up for public comment. And so that process in and of itself took a while. On June 28th, 2022, Biden's Department of Education submitted a guidance kind of telling schools what they perceived the Trump regulations to mean and how they were going to enforce those Trump regulations. And so really from 2022, for the good part of a year, the department was receiving those public comments and trying to orchestrate a final rule. In April 2024, that is when Biden's Department of Education issued its final Title IX rule, which went into effect / was supposed to go into effect in August 1st, 2024. Those regulations have been highly scrutinized, especially in comparison to Trump's regulations, which many people argue that the 2020 regulations really tried to level the playing field for both respondents, who are the ones accused of misconduct, and complainants, who are the individuals complaining of misconduct. It set forth more so like a courtroom experience when talking about investigations and when talking about hearings. And so there were a lot of proponents of those regulations that thought that it created a fair process where both parties had the opportunity to be heard. There was an evaluation of credibility, there was an evaluation of evidence, and then it was an impartial decision maker who would come in and hear all of that, hear testimony, and decide based on a preponderance of evidence what they thought happened. Those who objected to those regulations really took issue with the investigation process as well as the hearing process, there was a lot of skepticism put forward by survivor groups, talking about the new regulations would subject victims to re-traumatization, and that was really the main criticism of Trump's regulations. So I just want to go on and talk about kind of where these regulations agree and where they differ. And so, Dominica, you can go to the next slide. So in some areas, these regulations do agree with each other, and for more or less will remain the same. First one I want to talk about is training. Go on, Dominica. So the training of Title IX coordinators back in 2020 and even moving forward with Biden's regulations require that the training of school personnel involves training on how to serve impartially, which includes avoiding prejudgment based on facts, conflicts of interest with the parties, and bias. The schools are also required to publish their training materials for Title IX on their websites, which just gives a little bit more transparency to students, to staff, to parents, of what exactly is being taught in these trainings and so forth. Part of that training is that investigators must engage in an objective evaluation of all relevant evidence, including inculpatory and exculpatory evidence. You would think that would go without saying, but again, it was not until the 2020 regulations that was actually required from schools. And even today, there are situations that we come across where Title IX coordinators and investigators, still seem not to get this. We've had, cases involving, both females or males, one in which an investigator told a male student of ours that because he's a male, it's impossible for him to be sexually assaulted. It just doesn't work that way. We've also seen situations where it's been a female student who gets asked questions like, well, if you were so scared, why didn't you just leave the room? Those sort of things that are not in line with what they're supposed to being taught and the training that's supposed to be given. But it's just along the lines of what we are still seeing today. As you could imagine, some schools are better than others, but it's tough sometimes to get that implicit bias out of investigators and out of decision makers, but the regulations themselves really try to do a good job of making sure that is a fair and impartial process. Dominica? The next big area where things really aren't going to change that much is the assumption of non-responsible, as well as the burden to collect evidence. And so under the 2020 regulations and what will remain from the 2024 regulations is that a student or staff member accused of misconduct is presumed not responsible, or, in other words, presumed innocent. Additionally, schools also have the burden of investigating the allegations and collecting the evidence. And so when an allegation is made, a school will appoint an investigator. Sometimes it is somebody who is in-house. Sometimes it will be a lawyer that they hire from a different firm to go in to try to gather the names of all the witnesses and interview those witnesses to try and make try to make an investigation report based on all of the statements. This is important just because before 2020, when this wasn't in play, it put students into a tough position. If they had to go out and they had to talk to friends or other students about what they might have saw or heard from a night, all while they're trying to manage their own social lives, trying to manage school, trying to manage extracurriculars. And again, even today, it's not foolproof because we still see cases in which, investigators refuse to interview certain witnesses for whatever reason and so forth. I would say those are probably the three main areas that remain the same. Next, we're going to talk about kind of, where they differ, which is in a lot of different areas. So Dominica, if you don't mind skipping ahead too. So first area that's going to get changed is jurisdiction. Under the 2020 regulations, in order for an allegation to fall under Title IX, it needed to occur within the school's educational program, meaning it really had to occur on campus, part of a field trip with the school, things of that nature. If there was an allegation between two students that happened in an off-campus apartment, or, as they were, taking a road trip somewhere, Title IX didn't apply. The school had the opportunity to proceed with those allegations under its own separate student code of conduct, which oftentimes were pretty different processes compared to Title IX. And to put it bluntly, in a lot of times, those student code of conduct processes were less fair than what was available via Title IX. And so oftentimes, students found themselves in a position where if they were going to be accused with something, they would want to be under Title IX. However, because something happened, at a bar off campus or an off-campus apartment or house, it didn't proceed under Title IX. 2024 regulations are going to change that. Really, anything that happens under the control of a university or school is going to be covered under Title IX. And the verbiage from the rule is, so long as the accused is connected with the recipient school, those allegations will fall under Title IX. So when we're talking about an off-campus bar, off-campus apartment, as long as the accused is a student or a staff member or trying to reap the benefits of that educational system, Title IX is going to apply, which may very well make things much more consistent across the board when we're talking about allegations of misconduct. Dominica? The next big change, arguably the biggest, is going to be the way in which hearings and investigations are conducted. So the 2020 regulations mandated that schools employ what's called the dual investigator model. And that required colleges and universities to have a live hearing with or required the decision maker to be separate and apart from the investigator. The rationale behind this was you didn't want the investigator hearing all these different interviews, and as they're going along, hearing different statements from different people, making decisions on credibility, making kind of these predetermined decisions on responsibility. And so the investigator would do their investigation, they would hand over a report, it would go to a hearing in front of a different decision maker. And really, that would be the decision maker's first opportunity to hear all of the evidence, hear from the witnesses, hear from the parties, and then make a decision. The 2020 regulations also require that there was a live hearing with the opportunity for the party as advisor to conduct cross-examination of the parties as well as any witnesses. And so that's what I mean when I said they really try to make it more like a courtroom setting, where it gave advisors, which could be attorneys, the opportunity to do direct cross-examination of any witness of any party. Again, the rationale behind this was to try to create a more fair process and uncover the truth. The other big thing in the 2020 regulations is that at the end of any investigation, a investigation report was created that was then sent to both parties and their advisors, who had 10 days to review everything, add more evidence if needed, or respond to certain statements. What is going to change as far as the 2024 regulations is they're going to get away from the dual model or dual investigator model. Schools are permitted to have the dual investigator if they want, but they are also allowed to go back to the single investigator model, which again would basically be the investigator hearing all of the evidence as it comes in, and potentially making those determinations about credibility and responsibility from a very, very early standpoint before all of the evidence or all of the witnesses are even spoken to. As far as a live hearing goes, the schools do no longer need to have a live hearing. Instead, the regulations mandate that there is a process for assessing credibility when credibility is in dispute and relevant. What exactly that process needs to look like is really unknown at this point. Again, the fear is going to be, schools are given wide latitude to determine what that process looks like and what they're looking for when they're determining credibility. As far as the investigation report goes, that too is going to be allowed to be going away. Instead of having access to all of the evidence that's collected, schools only have to give access to relevant evidence. And that is evidence that they themselves, as the single investigator, determines to be relevant. Or they can also just give a report which accurately describes the evidence and the statements collected. Again, fear when you are talking about that is it really is up to one person and one person alone to determine what evidence is relevant and what evidence should get turned over. And also they get to, carte blanche determine what an accurate description of a statement is or what an accurate description of evidence is, which is particularly difficult if you're talking about cases where we've seen, hundreds and hundreds of pages of text messages between, two students who, were friends or were previously involved in a romantic relationship, making an accurate description of those text messages are going to be a little bit difficult. However, where things get a little bit confusing is that the Sixth Circuit has ruled that public school districts must have a live hearing with cross-examination. And so the 2024 regulations, even though they say that schools don't need to have it, as far as public universities are concerned, they're going to have to listen to the courts a little bit and still give that hearing, even though they may or may not want to. The Sixth Circuit has not given an opinion on private universities and what they need to do. And so I would imagine, when Ohio is able to implement the 2024 regulations, we may see private institutions going back to that single investigator model. Dominica?
Thanks, Tyler. Just really quickly, does this broader jurisdiction apply only to higher education, or does it apply in K through 12 schools as well?
It applies through K through 12 schools as well. Any educational system that is receiving federal funding is mandated to follow the Title IX. K through 12 is a little bit different because they don't need to have a live hearing and they didn't need to under the 2020 regulations. And so that is much more, the process looks like an investigation happens, a report is drafted, parties are able to respond to the report, and then it goes to a decision maker who reads everything and makes a determination from there. The definitions and scope of Title IX is also changing a bit with the 2024 regulations. In 2020, schools had to address sexual harassment if it was severe and pervasive and effectively denied a person equal access to a school program. In 2024, it can be severe or pervasive, so it doesn't need to be both. It also doesn't need to deny a person's ability to participate in school. It just needs to limit a person's ability to school. So again, you see with these new regulations, really they're trying to widen the scope of Title IX and find more allegations of misconduct that fall within the scope of Title IX, which may not be a bad thing. The other thing that is changing drastically is in 2020, the regulations did not explicitly address prohibitions based on things like sexual orientation, gender identity, or transgender inclusion. 2024 regulations do expressly prohibit discrimination based on those and other categories such as pregnancy status, sex characteristics and even sex stereotypes, which is a big change. And moving on to the next slide, which has been a very big point of contention as these regulations have gone into effect. As I mentioned briefly, even though these regulations are coming into play, the judiciary has an important role in really honing down what these regulations mean, both from a definition standpoint, but also from a practical standpoint. And so over the past several years, there's been a lot of district and circuit courts that have extended certain due process rights to students who are going through disciplinary processes, requiring that they be fundamentally fair and that they hit certain benchmarks. And I don't think the regulations are going to be able to go above and beyond what those courts have held. We've seen things in the Third Circuit that have extended the right to cross-examination to private institutions. Again, in the Sixth Circuit, they've held that public institutions do need to give the right to cross-examination by an advisor. We've seen things in various district courts across the country that have mandated that accused have ample time to review all evidence collected by the school. And so when we see schools in these jurisdictions that do have some of these rulings, they're going to have to follow the rulings of the court and have those sort of processes, even if the regulations don't necessarily require them to. Dominica? As far as the 2024 regulations themselves go, since April 19th, 2024, there have been a total of 8 federal lawsuits, where 26 states, including Ohio, have actually sought an injunction asking courts to block the 2024 regulations from going into effect as a whole. As of right now, each of these lawsuits have been successful. And so again, there are 26 states, Ohio included, that these 2024 regulations are not effective yet. And we are still proceeding under the 2020 regulations, until we get more clarity from the court on that. Really, and in August 16, 2024, the United States Supreme Court issued a ruling leaving those injunctions intact. And the important part of that lawsuit was it held the entire injunctions. And so the lawsuits themselves didn't focus on the disciplinary process. It didn't argue that the new disciplinary process was going to be unfair or anything like that. Instead, these lawsuits focused on this expansion of the definitions when we're talking about sex characteristics, sexual orientation, transgender inclusion, things of that nature. These states argued that that is not what was originally meant on the basis of sex, and therefore are trying to say that the Biden regulations can't go into effect and shouldn't go into effect. Rather than the Supreme Court making a ruling saying, we're going to hash out that argument separate and apart from the rest of the rule and let the rest of the rule go into effect, it said, as of right now, we're leaving the entire 2024 regulation. We're granting the injunction as it applies to the entirety of the 2024 regulation. And so again, as of right now, we are just kind of in a standstill waiting on further direction on where that lawsuit is going to go and how it ultimately shakes out. Dominica, you can go to the next one. The case that implicates Ohio in all of this is the state of Tennessee versus Miguel Cardona. The judge who ruled on this injunction and granted the injunction in favor of the states is Judge Danny Reeves, who was a George W. Bush appointee. And as you can see from his very first statement, which as you see here is that there are 2 sexes, male and female. That really gives the temperament of the court that's overruling this injunction. And, in my opinion, it makes it abundantly clear where the judge stands on the definition portion. As of right now, summary judgment motions have been filed by both parties. And it seems as if the decision of whether the 24 regulations can go into effect really come down to the interpretation of sex as it applied, when Title IX really came to fruition. The second aspect that will be one to watch again is that severability of, even if a judge rules that the definitions of Title IX can't be expanded, the disciplinary process and everything else that applies should still go into effect, and they can be severed from that. I suspect that at some point, those applications will be severed and disciplinary changes will go into effect. But it really will just be a waiting game until we see that. Dominica, you know, next slide. And so really, all this means is there's a lot of confusion going on in the Title IX landscape, not only for those who practice in this area, but also for the schools who are trying to figure out what they need to do when an allegation of misconduct comes to their office. And so now that we've talked a bit about where Title IX is, I want to shift gears and talk a little bit about what happens once regulations are in place, who enforces what schools are doing, and what they need to do. So, Dominica. So the entity that oversees Title IX and really enforces Title IX is the Department of Justice, the Office of Civil Rights. And so one of the options, if a student, staff member, or member of the public feels that a school is not living up to what they need to do under Title IX, they can file a report or a complaint with the Department of Justice. The Department of Justice will then come in and they will interview relevant parties. They'll interview school officials. They may ask for documents and so forth. And they do their own investigation to determine whether or not that school is living up to its requirements. One of the pros of doing this is, or some of the pros of doing this is, it's no cost to the person making the complaint. It's relatively stress-free on the person making the complaint because they don't have much of a role once the complaint is filed. And it oftentimes is a little bit easier for the school to comply with requirements or of what is being asked from them when that request is coming from the Department of Justice, as opposed to a law firm or a student, a member of the public, and so forth. Some of the cons associated with that is the investigation itself is a very lengthy process. Oftentimes it takes years for any sort of finality to them. The remedies are also forward-looking for the most part as well. So if there is a violation of Title IX, the Department of Justice may keep a closer eye on that school, or may put certain guidelines in place to make sure that the school is doing what they need to under Title IX moving forward. And the other con in certain cases is that, it's non-monetary relief ultimately for the person who filed the complaint, who in most cases feel like they were wronged by the school in some way, shape, or form. Dominica? So the other option of enforceability it really comes down to attorneys and clients, and it's litigation. More and more we are seeing institutions facing allegations through civil litigation that they are not living up to their obligations and not doing what is required of those. And we've seen an uptick in both complainant-driven lawsuits as well as respondent-driven lawsuits. So I want to talk about kind of what those look like a little bit. So Dominica, from a complainant side of things, the lawsuits that we are seeing, including some of the lawsuits we've been a part of, it's complainants arguing that schools are not doing enough to respond to allegations of misconduct or in some cases not doing anything. We recently filed a lawsuit against Cleveland Heights University Heights City School District, alleging this very thing, where it's 11 families serving as the plaintiffs for conduct that takes place over the course of many years. It's female and female students who were subjected to various forms of sexual harassment or sexual assault. And these students, when the time of the misconduct happened, they were in grades ranging from kindergarten through 10th grade. And in those situations, the complaint alleges that, the school refused to investigate these claims. They blamed the victims for what they experienced and kind of just threw any misconduct under the rug with statements such as boys will be boys or kids will be kids, and so forth. And so when we're talking about what a complainant lawsuit looks like, that's really what we're talking about. And Dominica, next slide. From a respondent standpoint, those look a little bit different. In those lawsuits, it's usually an argument that the school has done too much or has gone outside of their process. And in those lawsuits, the lawsuits are not focused so much on the outcome of the investigation, but instead on the process. And so the plaintiff needs to show that that sex was a but-for cause in the institution acting in whatever manner they did. And so more times than not, you are dealing with a student who is kicked out of school for an allegation or facing some other punishment as a result of an allegation against them. And the lawsuit focuses on, did the school apply their policy, or did they have a culture of discrimination against one sex or another? And some ways you can do that is by showing a culture of discrimination. We have a lawsuit against the University of Illinois, where one of the facts when we're talking about a culture of potential discrimination is that the only place to submit a complaint of misconduct is the Women's Rights Center. It's an office that's employs only women, and kind of focused on and giving the culture of only women can be victims of misconduct, and so forth. Other times you can use specific facts to show gender discrimination. Again, in the University of Illinois case, we saw a panel member have tweets talking about how they believe all survivors, which again talks about kind of just bias in terms of, trying to objectively evaluate whether a survivor, an alleged victim, needs to be believed or not. Or in a lawsuit we had against the University of Towson over in Maryland, one of the panel members had dozens of posts and tweets talking about that women can't lie about sexual misconduct allegations. He had asked questions of our client during that hearing about what his intentions were with the student who was accusing of. Did he actually like her? Was he just trying to use her? Just questions that really were not in line with the policy and did not, no matter what the answer was, did not show one way or the other whether there was a policy violation. And so that's really what the lawsuits kind of look like. And so next slide, Dominica. So the question is, if you have a client going through a Title IX issue, what do you do? And there's a number of things, because oftentimes as an attorney, if you see that a school is failing to do their part, it's important for the attorney to step in and try to at least put the school on notice of what's going on. Dominica, next slide. And so oftentimes that could be done with a letter to general counsel, especially when we're talking about, whether it's K through 12 or colleges or universities. There's either in-house counsel or there is counsel that they do have, that they hire out for these certain things. And so a lot of times what we will do is if we see issues arising, we will send a letter to general counsel letting them know of some of the issues we're seeing. And so, for example, we had a university that found a student responsible for sexual misconduct, kicked him off campus, kicked him off. He was a visa student, so it had visa implications as well. We were hired to handle the appeal. As we went through, we started seeing all of these kind of procedural defects throughout the process. And so you can see snippets of the letter in the next two slides. You know, the main points that they didn't do is the school did not give our client any notice of the allegations before he was questioned. He was asked by the Title IX coordinator to come in and have a chat with her. When he got in there, she started bombarding him with questions and just kind of did a shotgun approach of, you know, where were you? Who were you with? Why were you doing this? And he had no idea that that's what he was going in for. Going along with that, he was not accompanied by an advisor of his choice at the initial meeting, which is an obligation under Title IX. Dominica, next slide. When he asked about an advisor, if he needed an attorney, the school told him point blank, you know, we advise that you don't get an attorney. That's just going to make things messier. They did not provide him any time with a written report to look at the evidence. In fact, they didn't even create an investigation report at all. And so they sat down with him. They said, okay, our investigation's done. Now it's time for a hearing. And when he got to the hearing, had no idea who said what, who was even spoken to. During his initial interview, he had mentioned that there was an interaction between the student who was accusing him and his roommate. And they just refused to interview the roommate as well. And so if you go on to the next slide, Dominica. Same thing kind of on the complainant side of things. We've at times sent letters to general counsel or to Title IX coordinators expressly telling them what the issues we see are and how it is affecting the overall outcome. And so in this one, you will see it was an allegation that these things need to be done in a reasonable time frame, and we were up to the 9-month mark and nowhere close to the finish line. And so typically what you see a time frame of, it's 60 to 90 days with wiggle room for certain factors. 9 months, just completely unreasonable. It was unlikely that this was even going to get done in a full year's time. And what this does and the importance of these letters is it gives a chance for the school to correct the issues, or at the very least, if you need to be looking forward at litigation or at raising the possibility of litigation, if a school gets these type of letters and continues to violate Title IX, then it makes their conduct look malicious and it makes their conduct look deliberate, as opposed to just not fully understanding what they need to do. And so that's why it's important to send these type of letters. Next slide. And so some of the things to look at as you're kind of evaluating if a school is doing the right things is looking at jurisdiction. Is it non-Title IX? Is it Title IX? Did it happen on campus? Did it happen off campus? What regulation applied? Dominica, next slide. Familiarizing yourself with the policies and procedures. Is there a certain amount of days that they need to get a report to you? Is it a certain amount of days that the parties have to have with the report? Also knowing that these processes are not like criminal investigations. Students do not need to give any sort of statements. However, their silence can be used against them in a Title IX or a student disciplinary proceeding. The other thing that's important to know is if you are representing a student going through it, you are not the attorney, you are an advisor. And so everything that is said or done has to come from the student or the staff member's mouth themselves. So emails have to come from students, interviews and have to be done with the student. You are just there to advise them. And so it really becomes important because you essentially have to turn your client into the best advocate for themselves. Because if there is a difficult question that gets asked at a hearing or at an investigation, you as the advisor can't step in and say, here's how to answer this. You need to make sure the student is ready for any and all questions that come their way, or need to talk to them about whether it makes sense to make a statement verbally or whether a written statement is more suitable. Dominica? The other thing to keep in mind is just the overlapping processes. Oftentimes, Title IX allegations come with different processes, such as a civil complaint or maybe even a criminal investigation. And so the Title IX world does not wait for the criminal investigations to go forward or to figure out what's going on with those criminal investigations. The school is going to proceed much quicker than a criminal investigation often would. And so it's really important to know how to navigate both of those. Also important to know as you're going through the Title IX thing, anything that is said in a Title IX investigation can be subpoenaed by law enforcement and can be turned over. Oftentimes you see schools working in conjunction with law enforcement to share information. And so it can be a mess of pitfalls, and it can create a lot of traps to fall into if you are not, if you're not familiar with the way these different processes work. Dominica? And so again, as I mentioned, although the school has an obligation to investigate, this can be a bit misleading because while they have the obligation to get names of witnesses and go and interview those witnesses, you still need to be your best advocate because the school doesn't have subpoena power. They're not going to go looking for people's social media posts. They're not going to be looking for phone records. They will ask those witnesses, do you have text or voicemails or social media you want to turn over? But again, it's up to the parties then to collect that evidence and present it to the school because the school is not under the obligation to necessarily go looking for them. And so preserving that kind of information is certainly important. Dominica? Same thing to watch out for if you have a student going through these is all the places that evidence can be found, especially when we're trying to make a timeline with these smartwatches, with security cameras, even the entry keys to school dorms can carry a wealth of information about, you know, was John Smith or was Jane Doe actually at that building at the time of this alleged incident? Well, can we tell? Did he scan in somewhere? Were there cameras? Things of that nature. And we've had situations where, you know, allegations have been corroborated or contradicted based on these type of things, based on an Uber ride that was given, based on, you know, a sign-in sheet, you know, at a dorm room. And so the world of evidence is very expansive, and it's something to keep up with. Dominica? Other thing to keep in mind for Title IX is there are looser rules, especially when it comes to evidence. You know, in a criminal investigation or a criminal case or civil case, you know, polygraphs are a perfect example. A lot of times inadmissible in court. They are completely fair game in Title IX. And if they can be done in a way that's successful, we try to use them as much as possible because again, when you're dealing with those looser rules of evidence, sometimes you need every piece of evidence you can scrape up to support your client's case, whether they are the accuser or whether they're the accused. Dominica? And then lastly, as I mentioned, the school does not have subpoena power. And so something always to keep in mind when you're talking about, you know, what evidence is potentially out there is use other processes to your advantage. If a Title IX case has a civil component or there's maybe a protection order in place with a case pending, you can try to use subpoena power through those different channels to then get evidence that you can turn around and use, you know, to support your claims in a Title IX allegation. So just all those sort of things to keep in mind. Sounds like we do have a few questions. Dominica, I wasn't sure. Do you want to read them off? Do you want me to read them off?
Yeah, hi. Definitely happy to help by reading them off. We did get a couple of questions. We also got someone that said that you're a fantastic presenter.
Thank you.
Is there any data on the outcome of the hearings? Do schools need to publish that data or the outcomes when the misconduct is found?
So under FERPA, a lot of the records as it pertains to names and whatnot are protected. For public universities, those sorts of data of kids getting suspended and whatnot is something that can be requested. Oftentimes there is going to be a fight from the school to not turn that over. And even if they do turn it over, it's going to be heavily redacted just because of their obligations under FERPA and protecting that sort of information. Oftentimes in civil lawsuits, that is one of the main things we look for is, if you're claiming that you're not discriminating against males or females, well, show us the data that you have to prove that. So go through the data from hearings, how many females were suspended for allegations versus males, things of that nature. So it is available if you try hard enough and you go down the right avenue, but it certainly is not readily accessible.
Next question, is the portion of the 2020 rule providing that the decision maker cannot rely on statements from a party or witness who does not submit to cross-examination at the live hearing in effect currently?
So there was a district court out of Massachusetts that came in and actually struck down that provision. And so what it did is it left it up to the schools. And I've dealt with schools that do it both ways. There are certain schools that say, yes, if a witness or party does not show up for a hearing and does not subject themselves to cross-examination, their previous statements can't be used. I would say that's probably in the minority of schools. And I've had schools relay back to that District Court of Massachusetts case and say, that's not a part of the regulations anymore. But there is a number of schools that do either use it fully and say that we won't consider them at all, or they kind of say, we're going to meet in the middle somewhere and we're going to take it into consideration when we're talking about credibility. We'll make a note that that person, did not want to answer any questions.
Thank you. We got a couple of questions about trans students. Let's see. How does Title IX deal with transgender students? Is it based on gender identity or biological sex?
Yeah, and so that's where the 2020 and 2024 regulations basically create the most confusion. The 2020 regulations are essentially silent in the language of the regulation about how to deal with that situation. And so when those issues have arisen in court cases, because they certainly have, a lot of courts from around the country have recognized that a school can't discriminate against a transgender student or staff member. I'm not totally familiar about whether they've looked at gender identity versus, sex at birth. But it is something that the 2024 regulations are trying to expressly put in that language. And they're trying to aim more towards gender identity being the driving factor as opposed to whatever, the sex was at birth, or, there's not going to be a time distinguishing on gender identity. It's going to be what was the gender identity at the time of the alleged discrimination.
Thank you. Last question. How are male students protected from either false men or women's sexual assault allegations from other students?
It's a good question. The proponents of the 2020 regulations said the process that we've set forth in these regulations is how we are protecting any student from false allegations, because we have a cross-examination, and there's been a ton of lawsuits that have quoted Roth Bader Ginsburg when she talks about that, cross-examination is the ultimate way to find the truth. Oftentimes the 2020 regulations are criticized as a more conservative / more Republican thing. And, because it's under Trump, they can't be fair. And so you'll see a lot of people knowing Ruth Bader Ginsburg, where she stood on all these issues, using her line to say cross-examination is not about politics. It's not about, Democrat, Republican, anywhere in between. That it is what it is. It's the lifeblood of our judicial system for a reason, and it's the ultimate truth finder. It'll be interesting. And the biggest critique of the 2024 regulations is saying to strip cross-examination and to go back to a model where an investigator could sit down with the complainant and tell oftentimes a very compelling story, and then have the ability to make the decision about what went on later. It's a big critique of it.